This conference will now be recorded.
Great. I will go ahead and get started, and other people can trickle in as they come in. So first of all, hi everyone, and welcome back to the working group on compiling administrative records. It's obviously been a little while since our last meeting, back in July, but I think we're now on track to conclude meetings by this summer. So let me quickly take roll before I dive into today's discussion. Just please say here when I say your name. Kelly Dunbar. Noelle Green.
Present.
Great. Hey, Noelle. Lane Nemero.
Hi, good afternoon. This is Lane.
Great. How are you?
Good.
Melissa Rifkin. Adam White.
Here.
Hey, Adam. Eric Womack.
I'm here.
Great. Adina Rosenbaum.
Here.
Great. I see Megan Heller from the Commerce Department. Anyone else I am missing? Great. And then from ACUS, we have myself, Jeremy Grayboys, Reed Bull, and Matt Weiner, and a number of other attorneys on our staff. Great. So I'll go ahead and get started. You'll recall the charge of this working group is to study agency guidance on three interrelated kinds of administrative records: the internal record maintained during rulemaking proceedings, the public rulemaking docket, and the administrative record for judicial review. At our first three meetings, we addressed internal rulemaking records. I distributed the staff council report memorializing that third discussion before today's meeting. Before I go any further, does anyone have any comments on the report or any changes or corrections they'd like to make? Great. If you have anything additionally after that, just go ahead and email me after the meeting, and that's perfectly fine. So over the next hour and at our next meeting, we'll turn to public rulemaking dockets. Today's discussion concerns the essential components of and exclusions from public dockets. At our next meeting, we'll discuss the mechanics of docket compilation. Then we'll finish up with administrative records for judicial review at two meetings after that. So let's start with what materials are made part of the rulemaking docket, and then we'll turn to exclusions. So here I mean anything that's made public on regulations.gov, an agency's website, or physical materials in the agency docket office. At our next meeting, we'll discuss the mechanics of the docket and discuss distinctions between what's made publicly available online and other things that are made available in a docket office. So combing through statutes, rules, and the only agency guidance document I located, which is actually from EPA, I've identified the 13 categories listed on page 1 of the memo. That memo provides representative sample language for each category. I think the easiest thing to do is to step through each category in turn, and several of these may require more discussion than others. So beginning on page 4 of the memo with rulemaking notices, this refers to the sort of standard, notice of proposed rulemaking and the final rule. It could also refer to other documents, including ANPRMs, requests for information, that sort of thing. Notices withdrawing or terminating proposed rulemakings are another category. So ACUS has recommended agencies include all notices pertaining to the rulemaking in the public rulemaking docket. Some agency rules and guidance actually get into the details here. I think this is a pretty self-explanatory category though. But turning to you all, are there any comments on this category? Should agencies address rulemaking notices and guidance to help assemble dockets, or should they not? Are there any thoughts on what kind of specific guidance agencies should provide with respect to rulemaking notices? So just general thoughts on rulemaking notices. All right. I think this one is probably sort of bread and butter of what goes into a docket, right? Great. So turning to the second category, written submissions in response to rulemaking notices. And here we're really talking about public comments. There are public written submissions could come in other ways, but really we're talking about public comments here. So are there any comments on this category? Should agencies address written submissions in guidance to help staff assemble dockets? Should they not? I assume the answer to the first is yes, seeing as, again, comments are bread and butter of what goes into a rulemaking docket. Probably the more interesting question is comments that come in through other means, whether they're emailed directly to a specific person at an agency, or whether they're a response to a tweet or something like that. To what extent do you all think that guidance documents should address these sorts of things, and what level of detail should they go into? Lane.
So I would just note briefly that a number of the bureaus at Interior have a standard disclaimer, so to speak, or caveat to public commenters indicating that they should be solicitous, or they should be judicious about including personally identifiable information such as addresses, et cetera, in the comments submitted, because as an axiomatic principle, the department isn't always able to catch that PII.
Yeah, absolutely. We will certainly turn to that in greater depth. As some of you may know, we actually issued a recommendation on that subject in December, which working group member Adam White chaired the committee on that. So I'm sure we will get into more detail about that, and certainly more at our next meeting. Great. Any additional comments on public submissions? Excellent. I guess one other issue that occasionally comes up with written submissions in response to rulemaking notices is things that are incorporated by reference in written submissions or included as attachments. Are those worth addressing? I mean, I think agencies have come down differently on some of those issues. Are there sort of best practices you believe are worth addressing in guidance documents? Great. So let me turn next to procedural requests and agency responses. I only found this in a couple of rules, but maybe worth addressing here. These tend to be requests by members of the public to extend a comment period or have the opportunity for oral presentation. HUD and FEMA specifically require that those requests and any agency responses to those requests be placed in a public rulemaking docket. Outside those two agencies, I wasn't able to find any examples of that, but do you all have any thoughts on whether those sorts of records should be included in public rulemaking dockets, or at least should they be addressed specifically in guidance to help staff compile dockets? Great. So the fourth category refers to or relates to materials related to public meetings and hearings. Another big topic. This showed up in, I think, rules across the government. Some agencies are required by statute to hold some sort of public meeting or hearing. More frequently, they happen just because an agency thinks it's a good idea or at the request of a member of the public. There are also consultation requirements under various statutes and executive orders. So these sorts of public meetings and hearings, they don't refer here to formal rulemaking hearings, more informal hearings, but these can take place in a number of contexts. So a number of agencies seem to have developed rules to guide staff in deciding what materials associated with those meetings should actually enter into dockets. Whether it's materials distributed by agency officials at those events, agendas, handouts, that sort of thing, materials submitted by members of the public to agency officials of the public at the event itself, so sort of like public comments but submitted at the event rather than to regulations.gov, and sort of meta information about these meetings and hearings. Who was in attendance is the big one there. Agencies, I have, DOE, DOT, EPA, FDA, HUD, NHTSA, Coast Guard, all have different sort of formulations of which of those materials or all of those materials should be placed in public rulemaking dockets. Any thoughts from you all on, which of those materials, all, none, should be placed in dockets?
Yeah,
How should agencies provide guidance to their staff on what public meeting material should go into a docket?
Jeremy, this is Tim Mullins with DOT.
Yeah.
What you quote from us in our administrative rule is actually our procedures for ex parte communications. We call them public contacts because ex parte is not entirely correct for informal rulemaking. So that it should go in that quote should go in the next section. Our process for, if you have a public meeting, I think standard practice for agencies, which we didn't codify, but I think almost everyone does, is you put the notices for the public meeting in the docket, and if you have a transcript, which you are recommended to do, you would put that in the transcript. But that particular quoted language is for the next category.
I will move that.
No
I will click on their website.
Jeremy, this is Adam. I have a quick question.
Yeah.
I found this one very interesting. Just thinking about sort of how fast the technology is moving, I kind of wonder to what extent are agencies actually making video or audio recordings of their public hearings, given that it's so much easier now. And I'm just curious, I don't know that I go so far as to refer to that unless it's an increasingly widespread practice, but I'm just curious if you or the team came across instances of agencies specifically referring to the inclusion of audio or video materials from public hearings in the docket.
No, that's a great question. Certainly during the pandemic, almost all of these meetings are taking place in a virtual environment, and a lot of them, Gavin from our ICA staff is on the line. He's been tracking a lot of those developments. I don't know if you have any thoughts on that generally, but anybody else on the call have any thoughts about audio video recordings as technology improves?
There are definitely some, I can see upsides to audio recording, but I think there are also downsides to having audio or video recording if it's taking the place of a transcript, because transcripts are searchable in a way that recordings are not. So I know that, like, if I'm searching for something in a docket, it may pick up words in a transcript that I wouldn't be picked up in a video.
Interesting.
There's also the question
And
of
this is Eric Womack.
Go ahead.
Eric, go ahead.
Sorry, all I was going to say was to follow up on that comment, which I thought was a good one. Keep in mind that, those recordings, if they then are technically part of that docket, if there is later judicial review, that courts haven't necessarily caught up to the same level. And so it is going to complicate things how to use, audio recordings or video recordings in any court challenge.
Tim, you had a comment as well?
Oh, I don't know this for certain, but I believe we cannot upload audio files to our docket on regulations.gov. What generally happens, though, is that the agency will include a link on their website for it. Presumably, we could docket a link to that, right? Like a memo saying here. So, which is good, except the problem always, as we all know with links, is they don't always stay forever. IT sometimes changes all of our links without us knowing, which is why I think the transcript is still has value, even in the sense of even when you have video. But generally I don't want to say always, but generally if video is recorded, it will be somewhere available, if not the official docket. And then I guess to Eric's point, I don't know how in litigation whether or not it will be incorporated or not. I don't think the agency would oppose it because it's a public meeting that we have the recording of, but how the court could use it might be tricky.
Yeah, great points. I guess one other subcategory of meetings, we'll get into this in a little bit, but you have your sort of Eo12866 meetings. These aren't necessarily meetings they're not meetings that are actually coordinated by the agency themselves, but the agency takes part. I don't know if you have any, I think I found one agency that actually refers to Eo12866 meetings specifically and associating materials with those meetings with the docket. Any other thoughts on that?
So I would just note, this is Noelle from EPA. I would just note as well that the Eo12866, even that requirement to docket, or not docket, the EO requires agencies to make publicly available, right, certain materials associated with the interagency process. But even the EO spells out what materials those are. And they're not materials associated with whatever meetings OMB has with the public on pending rulemakings, right? It's just
Right.
the red line of, like, you know, proposal versus final, and then you identify which changes were suggested by OMB, et cetera, right? So just making a note of that.
Yeah, absolutely. The EO itself does not require that, or at least I've never read it to require that. I believe, and here I think I'm jumping around to the memo a bit. I am looking for which agency it was. I want to say it was HUD, but don't quote me on that. Basically, or maybe it might actually be in DOT's recent regulatory updates last year, 2 years ago. Basically saying if any staff members attend an Eo12866 meeting, they should take notes of it and introduce those into the docket. I don't know if any other agencies have done that. I certainly didn't find it other than that one rule. But that's sort of what I'm referring to, building on Eo12866 as opposed to the requirements of Eo12866 itself.
That makes sense. Thanks for clarifying. And sort of in response to that as well, I think that, like, would, you know, kind of just hearing that is sort of consistent, I think, with at least EPA's practice in terms of we have a transparency policy whereby, you know, any communications with outside stakeholders regarding a pending rule, like a proposed rule, during which we get like new information and that's relevant and all that, we document those communications. And of course, that, you know, summary goes into the docket for the proposed rule, along with any materials that may have been exchanged. So I could see like a situation where, like, if an EPA employee attended one of those meetings and then a stakeholder provided information that was new and relevant to the rulemaking, that in following that policy, that employee may document that and, you know, put it in the docket as needed. But I think, yeah, like you said, it's more tied to whatever the agency's practices might be with respect to kind of outside communications or information that's received, and not necessarily tied directly to the executive order itself.
Right, makes sense. It's tied to public events generally, or ex parte communications generally, as opposed to Eo12866 specifically.
Yeah.
Good to note. Perfect. Actually, related to that, materials related to ex parte communications. And Tim, here I will pull in your DOT quote as well. Certainly, we've talked about this over time. I think agencies have paid particular attention to this over the years. ACA certainly has. Ex parte communications in the informal rulemaking process. Many agencies have adopted rules governing ex parte communications, defined broadly as any sort of written or oral communication regarding the substance of a rulemaking that's not placed in the docket at the time it occurs. Plenty of agencies have developed rules to require those sorts of contacts to be placed in the docket at a later point. Of course, agencies can define what constitutes an ex parte contact rather differently, and at what point in the rulemaking process an ex parte contact sort of triggers that requirement. Something that takes place before an NPRM may not have to go to the docket, something after an NPRM doesn't go to the docket, that sort of thing. So the working group has previously discussed how agencies should explain to rulemaking personnel what constitutes an ex parte communication, whether there are any restrictions on ex parte communications, and how to document ex parte communications. I think we've already covered that sufficiently. With respect to the docket specifically, do you all have any thoughts on how rules or guidance should actually help staff decide which of those go to the docket? Is it all of them? Is it some subset of them? Any thoughts there?
Hey, Jeremy, it's Adam.
Hey.
So I have to admit, I was of two minds on this particular recommendation, or this part of the memo. I mean, given that there is, you know, pretty clear doctrinal requirements for agencies to use or to docket ex parte materials if they intend to use them later, I do sort of I mean, I wonder how much we need to push on this and sort of pick sides, and rather than leave it to agency discretion based on their own sort of practices, their own culture, and so on what the right moment is to docket an ex parte material. I mean, I'm in favor of more docketing rather than less, but I mean, I know that this is sort of a traditionally tricky subject, and so I just wonder if this might be an area where it'd be worthwhile for us to tread lightly.
It's a good point. Other thoughts?
Hi, this
As
is
someone,
Megan?
yeah, sorry, this is Megan Heller. So I'm actually working with someone in our leg reg office because she's working on this from the informal rulemaking side, and I'm working on it from the judicial review side. But I would say I certainly see a lot of value in favoring docketing, just because I'm finding with situations of maybe not even just necessarily informal rulemaking, although she's running into some of that, where if something isn't docketed and then it leads to a judicial review situation later on, there's a lot to regret then. We've gotten a lot of pushback. We've gotten some fairly angry administrative judges in a couple of cases. So just the erring on the side of more is better, I think, just based on what happens later on.
From a defensive posture, just over inclusion may be a best practice. Adina, did you think you were trying to get in there too?
I was just going to ask, as someone who's not in an agency, and I think on all of these categories, I look at them and think, yeah, put this on the public docket, because that's the only way I get to see these things. So this was described as sort of a tricky issue, and I'm wondering what makes this particularly tricky in terms of the timing. Like, I don't have a good sense of what the countervailing balances are of not docketing them.
I mean, I'm not in an agency either, so I'm probably not the right person to be, speaking to this, but I will anyway. I mean, like I said, I'm all in favor of disclosure and docketing, but I mean, we don't ask agencies to work in sort of glass phone booths, right? There is a certain measure of discussion that sometimes happens behind the scenes, and not necessarily every casual contact that it winds up touching on an issue that's currently docketed, might necessitate a full summary or account of it in the public docket. I mean, again, I'm in favor of more disclosure rather than less. I just wonder if this is one of those where, again, because there's Supreme Court DC Circuit doctrine on this, there's already sort of a gravitational pull in favor of docketing records of ex parte materials anytime they might actually become material to the agency's ultimate decision. But again, I'm just sort of rabble rousing a little bit and raising it. I don't have a firm view on the subject. I just thought it'd be worth considering.
Yeah, and I know at least the temporal aspect can get sort of tricky. I mean, we can draw bright line rules around the end.
From our perspective at DOT,
Sure.
sorry, I had to drop my video.
No, go ahead, Tim.
Yeah, no problem. I think this is an issue that you guys spoke to a few years ago on, and I think all the agencies have developed positions on it, and people can debate those positions. But I think for the purpose of maybe this project, it may be good to focus on the agency just being clear about what its policy is and doing its best to follow that policy. I know that we've shifted our position over time, but we've always tried to be public about it, because I think ex parte communications there's a strong reason to make sure that those policies that the agency has are public, and whether through an order or through regulatory text or whatever. So rather than getting into the ex parte for how broad ranging of a recommendation this might turn into, rather than trying to come up with a view on ex parte views, particularly given that ACUS came out with a recommendation on that in 2013, I think, it might be better just to explain that the agencies should have policies, or suggest agencies have policies and make them public and follow them, all of which are things for us to do.
Yeah, I think it's very fair. We don't need to relitigate something that's already been a recommendation. I think agencies develop their practices in this mostly in accord with those recommendations. I mean, the other tricky aspect of ex parte communications is the actual documentation, and we'll go into this a bit more in our next meeting, but what does it mean to document an ex parte communication? If it's an email, that's fairly easy. It's a document, you can associate the document. If it's a off-the-cuff in-person conversation, back in the days when we had in-person conversations, that might be a bit harder to document. So I don't know if you guys have any initial thoughts on that now. I know in the guidance that I've tracked here, agencies have taken sort of different tacks. Some have said some sort of recording or transcript, a memo, or just documentation that it happened with no real description of the content of the communication. We'll turn to that in greater detail next week, but does anyone have any initial thoughts now? Yeah, Lane.
Because there's not a raise your hand function on the go-to meetings, I'm just going to
do it.
Raise my hand.
Actually, noted earlier, this is our last go-to meeting, just meeting at ACUS, or second to last before we switch to Zoom. So
Sure. I just wanted to note that when we have an inception of an administrative record or a public docket, sometimes bureaus at the Department of the Interior formalize a template or a form that's called record of communication that particularly leadership and the politicals can rely on in the event they receive some sort of call or have some exchange, on campus or off campus concerning the subject matter of the rule. For a specific way forward, but I just note that's practice at some bureaus at Interior.
Yeah, absolutely. I think we discussed that with the rulemaking record, and that actually makes a lot of sense. It's the same form, I assume, for an internal record as well as the public rulemaking docket, and then the administrative record for judicial review. So it sort of kills 2 or 3 birds with one stone. Any other thoughts on documenting ex parte contacts for the docket at this point? Great. So I will turn to the next category, which is economic, environmental, and other regulatory assessments. And these can be required by any number of statutes and EOs. I think most of you, if not all of you, are familiar with most of these things. The RFA, the PRA, Eo12866, NEPA. There's a whole variety here. Any thoughts on generally docketing EISs, regulatory impact analyses, information collections, those sorts of things?
So real quick on EIS and NEPA, sometimes in certain rulemakings, those need a separate docket. I know for our fuel economy rules, we have to run them through a separate docket. So
Sure.
It's still docketing it, but just being mindful that it might be in a different docket than the rulemaking docket. In litigation, it would.
Interesting. Are the 2 dockets linked at all, or are they just refer to each other? Or not at all?
I think the rulemaking document, yeah. I mean, because it just occurs in different. I'm not even sure if we have to do it or if we just do that as a matter of practice. But
Sure.
I mean, they do reference each other.
Right. Great. Actually, Noel, if I can turn to you real quick, because I think you mentioned this at one of our first meetings, that these are traditionally placed in the docket at EPA, but not made part of the administrative record for judicial review. Is that correct?
So yeah, are you referring to the 12866 materials?
Yeah, absolutely.
Yes, that's correct. So we don't put it in the record because we still consider it to be deliberative, but to comply with the presidential directive, we put it in the docket.
Okay, great. Any other thought on these sorts of broad category of economic, environmental, or other regulatory assessments? And I assume in most cases, these are actually fairly discrete documents, so it's fairly simple to decide whether it goes in or not. Or it's in a rulemaking notice, in which case it's already in the docket. So I think probably fairly self-explanatory. So the next category is probably I think the biggest, most complicated, most nebulous category, other background materials. Part of this gets at sort of Portland cement type questions about what is the critical factual material underlying a rule? When does it need to be placed in the docket? If it's not placed in the docket, does that mean the public didn't have adequate notice of the decision-making process, that sort of thing? So, I mean, this could encompass a wide array of materials: technical studies, staff reports, data, methodologies, et cetera, et cetera. There's plenty of case law, especially the DC Circuit, that's developed on this point. consistent with this principle, Eo13563, it's an Obama era Eo, I believe, requires agencies to include relevant scientific and technical findings in the public rulemaking docket. How do agencies deal with this sort of broad and nebulous category of technical information or underlying factual information? Is there an easy way to explain this stuff to staff, or is it really a sort of you know it when you see it?
I guess I can chime in on that. So I think you basically summed it up. So it's one of those questions that's super case intensive, right? I mean, it's going to turn on the very intimate details of the particular rulemaking or other agency action sort of process that's at issue. That and there isn't really even the case law that is confined to, not confined, but the cases are in the context of particular rulemakings or actions, right? And so even the case law is very much based on the circumstances at play in that particular situation. But I think like what we try to tell our folks at EPA is, think about the docket as feeding into the record. No one wants to pretend like everything they're doing is going to get challenged, but when you're EPA, it's probably the case. So, sort of build your docket with an eye to the record. And even though your docket is potentially much broader than the record, it's sort of like, think about, is this something that is relevant to the rulemaking? Is this something that you may, in fact, end up considering, and therefore it would be in the record? And then if it's not in the docket, then there are going to be questions as to why was this in the record and not in the docket? And like you said, there are going to be questions as to whether the lack of this information, for the public to sort of inspect, whether that, inhibited their notice and their opportunity to comment on whatever you're doing. So it's sort of like, it's a broad amorphous category, sure, but the calls do come down to particular documents. But you should sort of be thinking of it as like, if this is in the record and not the docket, what kind of grief is that going to cause us, right? This sort of is this type of thing that the public should be fairly apprised of in order to meaningfully participate in the rulemaking. So yeah, there's no like black letter answer to that, unfortunately.
Yeah, I think it's fair. So sort of like a risk analysis, basically. There's no danger in putting a record into the docket, but it prevents something down the road, a remand down the road, might as well. Sort of like we were talking about earlier, the ex parte contacts, maybe over inclusion is the way to go here.
Yeah, it's certainly a risk. Yeah, it's definitely a risk assessment. And sort of like, so we like to say what goes into, unless your rule is covered under, I think like TSCA 411 and Clean Air Act 307D, like those two statutes impose like specific docketing requirements. But outside of that, there is no like black letter, here's what goes, here's what doesn't. And so it's sort of like, okay, what you put in your docket ultimately is not a legal question unless your rule falls into one of those statutes. But it does have legal implications, right? So that's sort of how we phrase it.
Absolutely. Is there much hand-holding basically between OGC and rulemaking staff on this, or does staff sort of after a while sort of pick it up and know what to do?
I think so for our offices that are very, very familiar with litigation, or not even litigation, but rulemakings, our heavy rulemaking offices, they really have, lots of experience and breadth of knowledge with that. I think there can be some hand-holding if we're talking about an office that maybe is initiating something for the first time pursuant to some recent authority or something like that. And so they may need a little more guidance, a little more close guidance on what goes into the docket. I get these questions on a pretty regular basis, but they tend to be very discrete questions as opposed to like general, what do we do here? So I think it varies.
Okay, yeah. Any other thoughts on this? So it's fair to say that a sort of...
Jeremy, this is Eric Womack. I just had one really basic question, which perhaps I should know the answer to. But when we're discussing, you might have addressed this at the last meeting or in the memo, but when we're discussing dockets, obviously regulations.gov, other things are electronically searchable and retrievable in real time. Is that the same for all of these categories, or are some of these categories just identifications of certain materials by the agencies during the process?
I think it's fair to say, I mean, I think a lot of these sort of background documents, if you're referring to an article that's available in the public domain, the agency, I think EPA even says in its rules, you don't have to, an article is available on Google Books or Google Scholar, don't go putting that in the docket as it's not worth it. You can just include a link or reference it. You can easily find it online. Or, you know, every time you cite a case, you don't need to include the case opinion. So easily identifiable information, I think, can be left out of the docket safely. I think most agencies have taken that tack. In other cases, you know, if it's ex parte contacts, I think some of them just basically say a contact happened, here's who it was, with underlying materials may or may not end up in the docket. So I think it probably depends agency to agency. That's what I got.
Yeah, I guess just relevant to the notion for this category, or like, say, reams of technical data, where I know that we've had cases where people challenge the lack of availability of, you know, just certain underlying raw data that an agency consultant may have used. Is that not being available? And I just wondered, when we talk about this being on the docket, exactly what are we referring to? Are we referring to making the data available, or just referencing the data on the docket?
I think it's a good question. Let me open that up to the group, actually. Any thoughts on data? But yeah, go ahead.
There's someone. Oh, so I think what happens at EPA, and I'm saying I think because I'm not, you know, involved in the actual rules that, you know, in terms of making those decisions as to what goes into the docket. But I believe that our practices generally, the raw data itself, we don't find it useful to include that in the docket, because, I mean, unless you're like a technical person with, you know, that kind of knowledge, we think that most times, or on balance, it might be more confusing than helpful. But I believe what the programs do is they will summarize the data. You know, they'll make calls as to what data is most important, and they'll summarize it in some form of a technical support document. And so it's not just like reams of charts and numbers, right? It's put into context, and it's kind of qualified, not qualified, it's qualitatively kind of explained in a form of a technical support document and other sort of background materials. I don't believe that the general practice is to just like dump raw data into the docket. That's kind of my high level kind of anecdotal understanding of how things go. So with all those caveats. And I just wanted to also address, I think Todd asked me to repeat the two statutes that have docketing requirements. And that's TSCA 411 and Clean Air Act 307D.
Great. Yeah, Todd will be preparing materials for our next meeting, so this is his area of expertise, so that should be good. Great. So, I mean, it sounds like, again, even with data, it's hard to give a hard and fast rule. It really just depends on what the data is and what it shows. I guess other issues, you know, a lot of the data itself could be protected. Adam, Todd, I think you dealt with that with protected materials. A lot of this underlying data could certainly be confidential commercial information or personal information. So those are other countervailing concerns. Great. Any final thoughts on sort of critical factual material, other background materials? Excellent. So I will move next to interagency communications. I think the main one here is Eo12866 materials, which we basically discussed. Any additional thoughts on whether those go into the docket or not? Again, as you've mentioned, Eo12866 obviously requires certain information to be made publicly available. A docket is obviously an easy way to make that available. Any additional thoughts on Eo12866 materials or communications between the agency and OIR generally? Great. Then I suppose in other cases you have communication between two agencies, not OIR necessarily. I know I found a couple of regulations, an FCC regulation where the FCC is required to seek the advice of the FAA, and that goes in the public rulemaking docket. I'm not sure how common those sorts of requirements are. Any thoughts on interagency communications, and I would say outside the general public comment process?
I can tell you ours. This is Melissa Rifkin from Pension Benefit Guarantee Corporation, and the board of our agency is made up of representatives from Department of Labor, Department of Treasury, and Department of Commerce. And every one of our rules has to be reviewed and approved by a representative from one of those agencies. That's per our bylaws. So we certainly do keep those communications to show that we've complied with our bylaws in our rulemaking process.
Sure, those are all docketed and made public, and just a
yes, absolutely. I guess that's a fairly easy example.
Right.
But that's just one instance where interagency communication is required.
Yeah. That's great. Others, even just informal communications between agencies, you know, if official agency A talks to official agency B, what happens with those communications?
I guess I have more of a question. Would we sort of stipulate or for the purposes of this question, understand that these are deliberative materials, they're interagency, they're pre-decisional, and they ostensibly express opinions or recommendations? So I guess that would maybe go to Melissa, for instance, if Commerce or Treasury, maybe Treasury is not a good idea, but a good example. If someone sent you an interagency, ostensibly deliberative interagency communication, would you include that in the docketed material and then maybe not in an administrative record? And if so, would that be by virtue of the bylaws you referenced?
That is a good question. And I have to think of how to answer it. Sometimes we do get comments and do alter our proposed or final regulations based on sort of that official communication. It's not just sort of a kind of a formality. We really do get comments from that, and yeah, we would certainly put that in the docket. And our we're challenged on litigation. So our rules are challenged so rarely. We almost think of them as one and the same, although I know that they are not. My guess is we probably would as well. We sort of have a policy that anything that is out the door the door of the building, you know, basically is public record, and we should treat as entirely public. So I would say in that situation, we certainly would put it in the docket, and I think we would put it in the administrative record because it shows how we came, you know, to this regulation. I think it has relevance there. So I guess that's how I would answer that question. But I think, but our agency just has a general policy of anything beyond the four walls of our building is public, and don't treat it as anything else other than that. So.
Yeah, this is Eric. I mean, I think from, you know, generally from DOJ's perspective, when you're talking about litigation, this is a difficult category just because it really starts to lap over into material that I think wouldn't be considered properly part of an administrative record. Now, I understand that there's a line there because some agencies will submit actually like formal comments during the process. And so it's interagency, but it's meant for public consumption. So it's really just trying, and I think agencies normally do, if it's going to affect the quality of the rulemaking, try to put that in the form of something that could be publicly disclosed. But it certainly is a fine line.
Yeah. Lane.
If I could just briefly mention a corollary issue, sometimes we deal with, you know, who is the custodian of that record? If it is an interagency communication from, you know, Office of Public Responsibility or one agency, if it originates with one agency in the FOIA context, if another agency receives it, typically a requester would have to go back to the originating agency. So that's an obtuse way of saying, I think you may have an issue about who is the proper record custodian for interagency communications, but maybe I'm parsing that a bit too.
Interesting. Great. Any other thoughts on interagency communications other than it is seems like it's a fine line and depends on really what the interagency communication itself is and what purpose it serves and how it's used in the rulemaking. Is that accurate? Great.
Yeah, I think that's accurate. I would just add as well that I don't know how this probably is very rare, but like, you know, when we deal with other agencies, we would just ask that like if there is something that they want us to include, to be very clear that like we're submitting this as basically a public comment. I don't think that ever happens, but typically we default to like if it's an interagency communication and it's on and like they're opining on something that's pending, so it's sort of like Eo12866-ish, right? Our default tends to be that it's probably not something that should go into the docket if it's, you know, if they're helping us kind of think through how we should be not phrasing, but, you know, developing things. But
yeah,
yeah,
that's great.
Right. I mean, I think you don't want to be inhibiting an agency from reaching out to a sister agency, you know, informally to get questions of expert opinion, things like that. But at the same time, you also want to have the administrative record reflect sort of the thought process and the things that went into the ultimate decision. So again, it's just, I think it's difficult to really draw lines here in terms of guidance.
Yeah, absolutely. Great. So the next category I think can probably be a quick one, draft rules notices. There's the occasional statute, I think EPA might have one that basically requires the draft, or maybe FDA requires the draft rules be made public in certain cases. Otherwise, you have Eo12866's requirements for significant rules. Does any agency have a practice of making draft rules and notices publicly available at docket? I think I know the answer, but I'll ask. I think that's my answer. Great. I will turn to rulemaking petitions and associated materials next. I would note that agencies have certainly developed different practices with regard to rulemaking petitions and whether the receipt of petition instigates the creation of a docket in the first place. And I know some of the rules here take different tacks when it comes to that. Any general thoughts, though, on making petitions or attachments to petitions or agency responses to petitions part of a docket, independent of an NPRM type process? All right, we'll let those rules speak for themselves. A couple of final things here, which are probably less relevant or maybe only relevant to a handful of agencies. One, advisory committee records. Two, sort of records specific to multi-member boards and commissions like Sunshine Act requirements, or transcripts, minutes, recordings, notices, votes, that sort of thing. And finally, indexes of the docket itself. Any thoughts on those three specifically?
So at EPA, our committees, so I'll note also that there's FACA, the Federal Advisory Committee Act, that has its own sort of requirements for committees to maintain their own records, and for the life of the committee. And that's records is like not as in narrow records, but just records like any scrap of paper basically that is like prepared for or by or for the benefit of a committee, they have to keep for the lifetime of the committee for the public to be able to inspect. And so we at EPA, our committees have their own, most of them have their own like websites. And so they maintain their records via that. And so the only time that I would see a committee like, including its records in a docket would be if it's like information that is pertinent to the rulemaking.
Yep.
But otherwise, I think those are pretty separate.
Yep. Great. Before turning to exclusions, because we have about 10 minutes left, any additions you would add to the sort of list of components on the first page? Are there any other categories we haven't addressed that you think agencies should perhaps address in guidance? or any recategorizations of these materials, or you think this otherwise makes sort of sense as a taxonomy? Great. So I will turn quickly to exclusions from public rulemaking dockets. I think this is fairly simple, at least in the abstract. I think in practice it gets more complicated, which Todd will illuminate us on next week, or next meeting. So I identified 3 sort of buckets of materials that agencies seem to instruct staff to exclude or consider excluding from public rulemaking dockets. The first are legally protected materials, which are basically things enumerated in statutes such as FOIA, the Privacy Act, Trade Secrets Act, Sunshine Act, various executive orders and agency rules. The second are materials for which agencies commonly invoke privileges, usually deliberative process privilege, attorney work product privilege, or attorney-client privilege. And the third are materials excluded for more pragmatic or procedural reasons. They weren't properly submitted, they're irrelevant to the rulemaking, or they're publicly available outside of the docket, as we discussed earlier with articles that are relied on by the agency but widely available are not necessarily added to the docket in whole. So turning to the first category of legally protected materials, I did identify guidance on protected materials generally. Usually didn't actually define what a protected material was, or not directly in the rule, but just said basically certain kinds of material shouldn't be put online, as well as specific guidance on confidential commercial information and national security information. Any thoughts from the group on guidance on protected materials generally, or specific categories of protected materials that should be excluded from the docket? Great. Do you guys think that confidential?
This is Eric again. One of the things that does pop up a lot that becomes an issue, I think, is things that are being submitted by commenters that actually do have some kind of potential privilege, but it's maybe not readily identifiable. There's also sort of like copyright and other issues that pop up, intellectual property issues. I don't know if that is within the ambit of this recommendation, but that is certainly a tricky thing.
Yeah, absolutely. And I know some agencies have taken the tack that copyrighted materials may be available in a docket office but online, and we'll certainly get into those issues next week when we talk about the actual, or next meeting when we talk about the actual compilation of the docket. Yep, Lane.
It's one sidebar issue here. I know that some of the public comments that came in recently contained profanity, and I know people at the Bureau of Safety Environmental Enforcement corresponded with their colleagues at EPA about how to deal with docketing those materials. As we sit here, I don't know what the resolution actually was, but and maybe beyond the scope a bit, but it's just sort of a one-off issue that we encountered recently. I don't think Solicitor's Office had a recommendation there, but.
Todd, you actually may know. I think we actually addressed that in like 2011, some recommendation which touched on obscenity submitted or something, but.
Yeah, and that's also been a subject of interest in Congress. I believe Senators Portman and Carper have released a report related to profanity in the rulemaking docket, listing actual words that frequently come up, various 4- and 5-letter words. So that's something that Congress is looking at now.
This is Matt. Senator Portman, there was some legislation floating around on that subject from Senator Portman. Do you know if that was ever introduced?
I don't know, but I will check up on that.
But yeah, it's an interesting issue. Is it made part of the docket? Is it made part of a docket only in a physical form versus electronic form, or only available in a specific office? Good questions.
So this is Noelle. I can't speak to the particular interaction that Lane referred to because I wasn't part of those conversations. But I know that EPA, and we have this on our website as well. We have a policy and whereby we do not docket profane or like threatening sort of comments. And we make that clear. Like we have on our website, we have like it's kind of hard to find, to be honest, but we have it where we provide guidance to the public on how to, submit meaningful comments. And in that guidance, we also say, but please know that if you are using profane or obscene language, it will not be added to the docket. So just putting that out there.
Yeah.
What's wrong with, I guess we had this sort of long debate when we were discussing this subject with some Hill staff. And it might be useful to look at that report that Todd mentioned, but I'm not sure we want to sort of lump all of these things into the same category. I mean, obscenity is different from profanity, and what's wrong with profanity? I mean, are we going to eliminate blasphemy too? I just think we might want to be attentive to some of the details here when we start when we actually address the subject. And one of the things we discussed, if you can, you can walk into a courtroom with a jacket that says "F the draft," Cohen versus California. Why can't you use the F word in a rulemaking comment? So anyway, we might want to parse some of these things out after we take a look at that report.
Absolutely. Great. I will hold off on that one for now. Let's close with privileged materials. What kind? I think EPA has the lengthiest guidance I've seen. Noel, certainly on privileged materials generally, about what sort of deliberative materials that may be maintained internally as part of a rulemaking record don't become part of a docket. I assume other agencies have guidance on this that just is not publicly available or that I wasn't able to locate. General thoughts on how to advise staff as to what sorts of internal documents should or should not go into a docket. I guess also for those of you who have the memo up, what do you think of EPA's description? Certainly the most, and I know, well, I assume this document that I found is still live, but if it's not, I apologize for that. But what do you think of this description? Certainly the most comprehensive description I've seen publicly, at least, of trying to help staff parse out what is deliberative, what's not.
Don't be afraid to be honest.
I assume these are, again, these are obviously highly fact-intensive questions, and I assume are rather complicated. So yeah, any best practices on helping, and what in many cases may not even be attorneys, parse out what is deliberative privilege, the type of thing that we sit here and argue about. Yeah, Lane.
I would just briefly observe that, of course, in the FOIA context, deliberative material, exemption 5 material is discretionary. It's a discretionary privilege or discretionary categorization, as opposed to confidential commercial information under exemption 4. So although we're solicitous about not including deliberative material on the docket, we really apply sort of a strict scrutiny standard in case we have a submission from a private party that may contain confidential commercial information. So.
Yeah, I mean, the one thing that's also, and maybe this is a question for EPA, is, it's a difficult question to sort of write this out, because hopefully in the guidance that agencies are providing to their employees, the notion is the stuff that you're collecting is sort of on the front end excluding, as a definitional matter, things that are sort of these interagency or intra-agency materials that are deliberative, because on the back end, it's kind of hard to explain how to then remove stuff from that docket, if that makes sense. I mean, there's, if you're talking about the ordinary civil litigation, the assertion of privileges, then you're talking about potentially segregating information and other things like that. And that's not often, I think, how we conceptualize the rulemaking docket and an administrative record from the front end, if that makes sense.
Yeah. Any additional thoughts on sort of how to advise staff to segregate, or identify and segregate potential deliberative materials or other privileged materials. Great. Well, it looks like we are about out of time, and I think we just made it through the categories I have here. Let me close asking any additional categories of exclusions that I've missed that should be addressed in guidance or that we should discuss in a future meeting.
So just quickly to answer the question that you just asked, Jeremy, in terms of more sort of advice,
Yeah.
I also often tell folks that we slap deliberative on stuff because we're, you know, we do it because it's internal and we think just to protect ourselves, but that is not necessarily the arbiter of what is actually deliberative. So I would advise that folks look at the actual content of the document, because just because it says deliberative doesn't mean it is. So I would just point that out too.
Oh my gosh, yeah, no, that's yeah, this is Megan. Yeah, no, I went through this in a big way with one of my clients over the last year because they slap deliberative, like non-attorneys slap deliberative on everything, including things that are like going to the legislative branch and stuff like that, where I'm like, that's not deliberative anymore. There's no privilege on that, or things that are like, oh, we don't really care for it, then why did you put deliberative on it? So yeah, that's something that I've had to, then with like reviewing attorneys, I have to work with who have only been attorneys for a year. I have to talk through them like you have to put your fresh eyes on this, because just because your clients are stamping deliberative on everything that's maybe kind of non-final does not mean that anyone who's put that word down actually knows what it means. You can tell I have strong feelings about this.
And if I can just add, this is Kelly Dunbar at WilmerHale from a sort of outside private, litigating against agencies perspective. I think this is really an important issue where it may be beyond the scope of what ACIS can accomplish, but having established sort of standards for what counts as deliberative, I think will, from an agency's perspective, help reassure courts, which, I think, at least during the last administration, showed more willingness to sort of pierce behind claims of this is the administrative record and everything that's not here isn't. And I think, I've had cases litigating against the government where I felt like, and I'm not suggesting this is the agency side, it's probably more the litigators who are picking and choosing to include things that probably otherwise would count as deliberative but are helpful to the overall agency defense of the rulemaking, which sort of providing from an outside counsel perspective no ability to, since there's no logs typically like there would be in civil discovery, to figure out if other similar materials are getting withheld on pre-decisional deliberative privilege grounds that contain information that is harmful or arguably harmful, to the agency's defense. And I'm not suggesting anyone intentionally has done that in any case I've litigated, but I do feel like courts, when faced with, at least some agency lawyers who might not be able to sort of defend a coherent concept of what the deliberative process privilege encompasses in a rulemaking, and when you then look at a document that's included in the record that's maybe a staff report, for example, is that deliberative because it's pre-decisional internal communications? I feel like sometimes I see those included. In other cases, I could imagine why they'd be excluded. And so this is an area where I do think some type of consistency would sort of benefit both agencies and make the whole process smoother. But I understand that is probably a Herculean task, beyond the scope of what we're doing here. But that's just sort of a outside counsel perspective on this.
Yeah, I mean, I think it's at least part of our task, certainly, not necessarily to come up with a definitive determination of what counts as deliberative, but at least to recommend that agencies try to come up with one if it's a best practice, and to provide any examples I think that we've located of what to include in those definitions. And not too many. I think EPA is the closest I've seen. Bravo, Noel. But yeah, it's a Herculean task, I think. But any additional thoughts on that before we close today? Great. With that, I will close. I see we're 4 minutes over. But thank you all for attending today. Hopefully we'll schedule another meeting. I'm hoping for late March or early April. And I will be in touch soon. Thank you all.
Thanks, everyone.
Thanks all. Take care.